so much for being here. My name is Amy Wilhite. I'm the Director of Communications for the Tennessee Attorney General's Office. Today you'll be hearing from Tennessee Attorney General Scarmetti, who will be making a few comments, and he will also be taking questions. So I will now turn it over to him, and feel free to go ahead, General Scarmetti.
Thank you, Amy. This case is about protecting kids from the consequences of decisions that they cannot fully understand. Kids on puberty blockers and hormone treatments for gender dysphoria face serious risks of losing their fertility forever, of losing their sexual function forever, of dealing with medical conditions for the rest of their lives, including blood clots, tumors, bone density disorders, cognitive development impairments, and others. The medicalization of youth gender dysphoria has moved very far, very fast over recent years. The number of cases has exploded. One researcher identified a 4,000% increase in the number of adolescent girls seeking hormone treatments. And this explosion in cases has been driven by ideological pressure, not by scientific evidence. Over and over, systematic reviews have shown little to no benefit of these treatments for kids. That's why many European countries that pioneered the use of these treatments for kids have recently reversed course and severely restricted them. They looked at the evidence and they determined that the risks far outweighed the benefits. The people of Tennessee, acting through a bipartisan supermajority of their elected officials, made a similar choice. They passed SB 1 to protect kids. Half the states in the United States have done the same. The Constitution allows the states to protect kids from unproven, life-altering procedures based on uncertain science. The states have exercised the power to regulate the practice of medicine for hundreds of years. It's one of the fundamental things that they do. And Tennessee's laws draw a line based on age, which is something that the laws do all the time. The other side argues that SB 1 discriminates on the basis of sex because it prohibits cross-sex hormones for kids. But this misses the common sense fact that boys and girls react differently to different hormone treatments. The law targets the harm. It does not target on the basis of sex. It regulates regardless of sex. As Justice Ruth Bader Ginsburg, the greatest feminist in the history of the court, recognized, there are enduring physical differences between the sexes. There just are. And the Constitution does not require legal absurdity in response to biological reality. The dramatic and unexplained increase in the use of these life-altering procedures on kids is exactly the sort of situation where the state should take notice and regulate. Now, adolescence is hard, and gender dysphoria is a heavy burden, and we need to remember that. But the evidence shows that the large majority of kids dealing with gender dysphoria will grow out of it unless they're put on these medications. Tennessee's elected officials carefully considered the evidence and passed a law to protect Tennessee kids. The Constitution allows this. We look forward to a decision from the court. I am glad to take your questions.
Tennessee law sets a standard for the United States that it should be adopted in other places.
So I think the question was, does Tennessee law set a standard for the United States? In the United States, each state makes its own decisions. Different states reach different conclusions. Different states elect different people. That's the way the country works. Tennessee's standard is constitutional, but we have 50 separate laboratories for democracy. Each state is allowed to make its own decisions. So the question is about whether a heightened degree of scrutiny should apply. I think we made a good argument. The way that you categorize the classifications in the law are going to be driving that. This is a different situation than the court has considered before. We think rational basis applies. We think Chief Judge Sutton got it right at the Sixth Circuit, and we'll see if the court agrees.
How many kids in the state of Tennessee do you think are actually impacted by this? And if the court rules in your favor and allows the law to stand, what should happen to those who have already started undergoing transition services?
So the question's about numbers in Tennessee. I don't know the numbers offhand. With respect to treatment, the law has provisions related to differently situated kids.
Vehicles to treat gender dysphoria that are separate and apart from gender, these surgeries as well as these medicines, and we can provide appropriate care for kids. It's also inappropriate to characterize this as a fight between the left and the right. We see many of those in the gay and lesbian community who are equally as outraged about what we're doing with kids. Very pleased with what states are doing to protect children, and Alabama will continue to defend its right to protect our kids.
We also have Attorney General Alan Wilson of South Carolina.
I'm honored to be here today to support Tennessee, the state of Tennessee, in passing reasonable protections for its children. What's at stake here, as the Attorney General of the state of South Carolina, we have a similarly situated bill. And what is at stake right now is, can states pass reasonable laws that protect and promote the health and welfare of children? We pass laws that place reasonable restrictions on whether parents can put their children in the front of the car. We pass laws that put restrictions on whether or not a child can buy a tobacco product or an alcohol product or go into an adult entertainment facility. We do this already as states. It is inherent in states' police power to protect laws or to promote laws and in place laws that protect the health and welfare of our children. We do it already. What concerns me is that you have dueling sciences, you have people on both sides debating the medical nature of transgender. You're having children as young as 6, 7, 8 years old trying to commit or engage in an irreversible medical procedure, and we have people saying that the state should not be able to debate those issues, should not be able to weigh those issues. You're saying right now that a 12-year-old can engage in chemical castration and gender mutilation without having the states debate whether or not they have a right to regulate this. And so as a representative of the state of South Carolina, I'm here to support Tennessee's right to protect the health and welfare of children in the 25 states that have passed similar laws, as well as more than half a dozen countries that have already pulled back these types of laws. So I want to thank the state of Tennessee, General Scarametti, General Marshall, and so many amici states who are represented here today. Thank you very much.
Thank you so much. And if you need any information from our office, we'll be here. Let us know. We'll be glad to get that to you. Thank you.